took 40 minutes. How much time will you take?
Just 2 minutes, my lord.
2?
Yes.
Oh, proceed.
Or even less. My lords, my lady, my name is Benan Diritu. I shall be submitting on the reliefs sought on behalf of the third petitioner. Relief number 1. Your lordships, we are seeking a declaration from this court that the impeachment process conducted under Standing Order 64-2 violated the Articles 118, 145, 47, 50, and 10 of the Constitution. Relief number 2. Your lordships, we are seeking a declaration from the court that the modalities placed by the first respondent in respect to the public participation forums of 4th October 2024 fell below the threshold of proper, effective, and meaningful public participation as envisioned under Article 10 of the Constitution. 3, we are seeking that the modalities placed in regards to the public participation held on 4th and 5th October were in disregard of the court order issued in Kirogoya in petition E014 of 2024. 4, we are seeking a declaration that the public participation held on 4th and 5th October 2024 did not meet the constitutional standards under Article 118 of the Constitution. 5, we are seeking a declaration that the Senate violated Article 118 of the Constitution by failing to conduct public participation. 6, we are seeking a declaration that the impeachment process undertaken by the first and third respondents in view of the public participations held on 4th and 5th October fell below the threshold and therefore unconstitutional, null and void. This in regards to Article 10 of the Constitution. 7, we are seeking a declaration that the appointment of a select committee by the Senate is mandatory in the impeachment process of a president and a deputy president. 8, the proceedings in regards to the impeachment process outside the select committee were unconstitutional. 9, we are seeking a declaration from the court that the Standing Order 64-2 should be declared unconstitutional to the extent that it provides timelines which are not compatible with the constitutional requirements. 10, we are seeking an order of certiorari quashing the National Assembly resolution of October 8th, 2024. 11, we are seeking an order of certiorari quashing the Senate resolution of October 17th, 2024. And last of the reliefs, your lordships and my lady, we are seeking is costs to the third petitioner. I humbly submit. Thank you.
Thank you.
My lords and my lady, if it pleases you again, my name is Wambui, Shadrack Wambui. I appear on behalf of the 9th petitioner. My lord, what is before you is our amended petition dated the 28th day of October 2024. It is supported by an affidavit sworn by Ms. Dorcas Mwai, dated the 29th day of October 2024. My Lord, further to that, and in support of my arguments or our arguments, we have filed submissions and a list of authorities, both dated the 27th day of April 2026. And my lords and my lady, on our part, we will wholly seek to rely on our written submissions and the factual matrix that has been set by the deponent of the affidavit sworn in support of the amended petition. My lords and my lady, if you permit me, just briefly to highlight My Lord, the ninth petitioner being a public benefit organization, thank you. My Lord, the ninth petitioner being a public benefit organization and speaking on behalf of the public indeed appreciates the opportunity granted by these proceedings, at the very least, to ensure that the impeachment process that was conducted leading to the removal from office of the first petitioner, His Excellency Rigathi Gachagua, from office, is one that is solely and not a political process, but is one that is a sui generis constitutional process that primarily is legal, though characterized by politics. Away from the political characteristic of an impeachment process, my lords, our duty as the ninth petitioner is to persuade you to making a finding that the process, as we witnessed on the 9th day of October 2024, together with the events of the 17th day of October 2024, leading to a resolution of the Senate to have the Deputy President, the former Deputy President, impeached from office, was done in haste, was done contra-constitutional. And my Lord, as I shall demonstrate, the Senate, in our very humble view, appears to have walked over the very provisions of Article 145 of the Constitution. My Lord, my arguments will be split into two. Firstly, I will wish to draw the attention of the court to the Hansard proceedings of the 9th day of October in an attempt to demonstrate to the court that the facts provoking the petition before court are not in dispute. It is not in dispute that the Senate, having had an opportunity of considering whether the motion for the removal of the Deputy President will be considered at the plenary or by an 11-member committee, opted in their wisdom to have the motion considered by the plenary. My Lord, to that extent, the question that the petitioner will be urging the Honorable Court to consider is whether the very dictates or the authority that flows from a reading of Article 145(3) of the Constitution permitted the Senate to have an option on whether the matter should be decided by the plenary or the matter by the constitutional dictate ought then to have been considered by the 11-member committee. My Lord, I make reference, express reference to Article 145(3), particularly 145(3)(b), where the Constitution dictates that the Senate by resolution may appoint a special committee comprising of 11 of its members to investigate the matter. My Lord, while the word may be interpreted to mean that the Senate had the discretion of opting to have the matter deliberated by the plenary or by the 11-member of committee, the position that we humbly hold with respect, my lady and my lords, is that regardless of the word may, the Constitution so demanded that the Senate proceed to have the matter heard and determined by a select committee or a special committee of 11, as opposed to having the matter decided in the plenary. My Lord, my persuasion or our persuasion to move the Honorable Court to making a finding that the use of the word may in this instant have given a command to the Senate to have this matter decided by the special committee is informed by the growing jurisprudence within the Republic of Kenya. Particularly, my Lord, I will wish to make reference to the Court of Appeal decision made in the year 2023, Civil Appeal, my Lord, number 3 of 2023. This is the case between the National Assembly and another versus Okia, Okoiti, Omtata, and 55 others. My Lords, with humility, I will wish to draw your attention to paragraph 145. Paragraph 145 of the said authority, where, my Lords, borrowing from the jurisprudence that has been set by the Supreme Court of India, noted that it is settled that the word may is capable of meaning must or shall in light of the context, and that where a discretion is conferred upon a public authority, coupled with an obligation, the word may, which denotes discretion, should be construed to mean a command. And my Lord, this Honorable Court has an easy task of interpreting the Constitution, because the very same document that you are called upon to interpret has already, under Article 259, given us modalities through which this Constitution should be interpreted. It should be interpreted in a manner that the Constitution is always speaking. So much so that by any reading or interpretation of the Constitution, then the Constitution should not be read to be speaking to us in a way that causes confusion in our interpretation, but in a manner that guarantees us clarity, in a manner that promotes the very values and principles of the Constitution and the human rights and fundamental freedoms of the person aggrieved. My Lord, going under or going down the reading of Article 145, is that there are certain safeguards that have been put by the framers of the Constitution to ensure that a party, in this case, either a president or a deputy president facing the motion of impeachment, enjoy certain safeguards to ensure that his right or her right to a fair trial is not run over. And this is by ensuring that the special committee, this is particularly Article 145.4, the special committee is mandated by law, by the use of the word shall, to investigate and prepare a report presented within 10 days on the particulars, if at all, the particulars of the allegations, if at all they have been proved or not proved. The writing of this report, and we submit with humility, is to ensure that two fundamental things are done. First is that the other members of the Senate are properly informed of the allegations that have been substantiated. And secondly, to grant an opportunity to the deputy president or the president who is facing an impeachment motion, the opportunity of understanding in full flavor the accusations that have since been substantiated, to permit them the opportunity of answering substantively to all the questions that have been, or all the allegations that have been made against them. In this case, as it were, when the Senate on the 9th day of October 2024 decided to interpret Article 145.3 in a manner that gives them the discretion of choosing or opting on whether the matter should be heard by the special committee or the plenary. It means that they indeed substituted the place of the special committee with the Senate committee, or the Senate sitting together as a committee. This, in other words, would mean that if, assuming for argument's sake, that the court is to make an inference that the word may, in this case, was or did give them the discretion of choosing, then it therefore means that a very crucial step that is required under law was missed by the Senate at the point of deciding that the former Deputy President, His Excellency Rigathi Gachagua, should be impeached from office. And this step, my lords and my lady, is that of tabling a report for the purpose of furnishing the respondent with sufficient notice on the allegations that have been substantiated. So, my lord and my lady, the argument that we make is that to the extent, my lord, that the plenary or other members of the Senate proceeded to hold that 5 out of the 11 grounds had been substantiated without affording the first petitioner an opportunity of answering to the grounds that had been substantiated. That in itself meant that a crucial step dictated under Article 145 of the Constitution was missed. My lord, as I mentioned earlier, that the reading of the Constitution as a document that is always speaking to us should be taken to be speaking to us with clarity. This is to mean that if we are to assume that the word may, as indicated under Article 145(3), does not place an obligation on the Senate to form a special committee, then it therefore means that, as it were, and as we find ourselves in, we get ourselves confused, because one would wonder if, in the absence of this special committee, why will the Senate then be writing a report to itself? If we are just to allow the interpretation as was made of this article by the Senate to succeed, why then would we permit or allow a situation like that to succeed? My lords and my lady, your brothers and sister at the Court of Appeal, over and above borrowing the jurisprudence from the Supreme Court of India, had the following to say. And they noted that the court, as this court is called upon, has a duty to examine the scheme of the Constitution, the purpose and the object underlying the provision, and, with emphasis, my lords and my lady, the consequences likely to ensue if the provision is interpreted one way or the other. So that, my lord, as you retire to the privacy of your chambers to write a reasoned judgment on this issue, we pray with humility that you return a finding that indeed, for the sake of posterity, it is indeed incumbent on the Senate under Article 145(3) to, by law, establish, when invited, a special committee to consider whether the allegations made by the National Assembly or the mover of the motion by the National Assembly, in this case, the Honorable Mutuse, was, number one, investigated, number two, whether there was substance in the motion for the removal of the first petitioner before the Honorable Court. So, my lords, without saying much, I will yield the floor to my colleague, Ms. Waithera, to also highlight a few issues that I may have missed out. That is all from me, my lords and my lady. Thank you.
Thank you.